Test, test. All right. Well, we will go ahead and get started this time. I want to thank everyone for being here for the House Judiciary Committee meeting. It's probably our best in-person attendance that we've had so far this year, being right after session. And so I want to thank everyone for taking the time late on this afternoon. We have two bills on the agenda today. First bill up is HB 624. Representative Chairman Taylor is present with us. We have a substitute on this bill, and members, if you would take a close look, LC 470930S is a sub we're going to be working from. Before I get started, I do want to recognize our esteemed guest, Judge Bert Guy from Brunswick Judicial Circuit's here with us today. Judge Guy, honored to have you with us, and thank you for being here. So we'll go ahead and recognize Chairman Taylor at this time to present your bill. I got you now.
Thank you, Mr. Chairman. I appreciate the opportunity to present this bill to you. I represent the South Georgia Judicial Circuit. It's located in the 2nd Judicial Administrative District, and it's comprised of 5 counties: Baker, Calhoun, Decatur, Grady, and Mitchell. There are 2 judges for the circuit, the Chief Judge, Judge Wallace Cato, and our presiding judge is Kevin Chasen, and he's located in Grady County. Like every circuit in the state, our crime has increased and there's need for more judges. You may have seen in the news, we just had a terrible incident this weekend where we're located on the Florida-Georgia border, and we get quite a bit of traffic coming up from Florida. And we had a deputy that was shot and killed this weekend. So there is a need. The crime is there. We have drug problems coming in from Florida. Anyway, they've been on the needs list for several years, but they've been very patient. We now are to the point where the shortage is critical. The South Georgia District Circuit has not had an increase in the number of judges since 1978. Our ranking is higher than some that have already gotten new judgeships. We are at 1.8 per judge load assessment. And I would note that the bill includes the effective date. Originally, we had it for July, but we have changed it to next year so that it will fit in with the budget. We've gone ahead and checked with them to make sure that we would have it. I would appreciate your consideration of this bill. I've given you copies of what came in from the council, and would appreciate it. There is a great need there for our judges.
Thank you very much, Chairman Taylor. And I will note, as was stated by the author, we have the letter from the Judicial Council showing that the South Georgia Judicial Circuit is the top circuit in need of a Superior Court position. And then we also have a letter from Judge Chasen, Chief Judge of the circuit, with respect to the need. And Madam Chair, have you received any feedback that's called into question or been disfavorable of this proposal for?
None whatsoever. Everyone in the communities surrounding are very much in favor of it.
Well, thank you. And I think I can speak for every member of the committee when I say our deepest condolences for the loss from,
thank you.
From recently. All right. So we will now hear any questions, if there are any, from members of the committee. Any questions? All right. Any questions online? Oh, no members online. All right. Well, at this point in time, I'll hear a motion. So motion do pass from Chairman Gunner. Is there a second? All right. Motion is second. This is House Bill 624 LC 470930S. Any amendments? Further discussion? Hearing none. All those in favor signify by saying aye. Any opposed? Passes unanimously under rules.
Thank you. And this is the best I've ever done in judiciary. Thank you very, very much.
Don't let the word get out. So if Chairman, if you don't mind, we have a rules committee form. If you'd like to sign here, I can go and sign it for you right now before you leave. Yes, ma'am. They're available right here in the office. So, all right, very good. Well, we will move on now to Representative Leverett's bill, House Bill 620. And what number are you?
7, Mr. Chairman.
Yes, sir. All right, go ahead and present your bill.
Thank you, Mr. Chairman, and thank you for placing this bill on the agenda. There is a substitute which I believe should be on everyone's desk to this bill, which is the result of some collaboration and revision that was made by me and also the fiduciary section of the state bar, as well as some representatives of the probate courts. So the bill itself just relates to minor settlements, which is as everyone knows, I guess, not small settlements, but settlements involving minors. And there is a provision in Georgia law currently that provides, or a section that provides, if the settlement is 15,000 or less, the settlement can be done without appointment of a conservator or any kind of approval. And this bill would raise that number from 15,000 to 25,000. The reasons being frequently the costs of getting conservatorship and all those sorts of things would consume the settlements in those cases. And then there are other changes to additional code sections that just maintain to the consistency of that amount. And then we do introduce the concept of gross settlement and net settlement, and have provisions in 2933 that further define what kind of approval, if any, needs to be obtained. And it depends on the amount and whether there is a case pending at the time in which that claim is being asserted. Generally, if there's a case pending, the approval would be obtained through that court. And if the amount gets to a certain level, it also has to be approved by a conservator, but a conservator is not always required for some of the smaller settlements. So I believe this kind of brings the code more in line with the economic reality. It still requires the posting of a bond. It just delays when the bond has to be posted, because until the case is settled, you don't always know what a reasonable bond amount is. So when the case is to be settled, the bond has to be posted at that point. And I do have one additional amendment I'd like to offer, Mr. Chairman, to Section 9 on line 253. It's just really more stylistic. Well, not necessarily. It actually is to rectify what I believe to be just an error in terminology that still lingers. That Section A of that code section says, unless otherwise provided in this code section, any person who seeks to qualify to serve as the personal representative in an intestate estate or as a temporary administrator should be required to give bond with good and sufficient security. The next sentence says, a guardian or conservator appointed without bond shall have no authority to receive assets of the estate until a bond is posted. We believe that the subject of that sentence, a guardian or conservator, is actually incorrect. It's supposed to refer to the previous sentence, and it should read, such personal representative or temporary administrator appointed without bond shall have no authority, etc.
All right, we have a few questions. Representative Evans. Representative Reeves.
Thank you, Mr. Chairman. I don't have a question. I just want to thank you for bringing this. I do a lot of probate work, and the reality is you do deal with situations where a child is entitled to, $13,000, $14,000, and believe it or not, a bond and something like that can cost up to $1,000. And then the conservator, if they're not paying out of their wallet or paying out of their pocket, oftentimes it's parents who just pay the fees, but the filing fees and the conservatorship and the guardian, if there's a guardian ad litem required, it adds up. And so, $14,000, once they reimburse themselves, can turn into $12,000. And that's a significant portion. So I think that these are very good changes, and I'm very glad to see this.
Thank you. I wish I could claim credit for the original idea, but I'll certainly relay that to the folks who gave me the idea.
Chairman Oliver.
Forgive me for missing the first part of your presentation. The changes from the bill as introduced to sub were what? Is that what you were talking about the whole time?
Yes.
Or?
Well, I think initially, yes, ma'am. That is what we were saying. We initially filed this and we received some comments from the fiduciary section. So we tried to incorporate all of those that we could. We actually incorporated all of them. And I believe now that the sort of the interested parties, being the fiduciary section, the probate judges, they're all in agreement with the text of this bill. So it's sort of that unusual situation where everyone's happy.
The reference you made, a possible amendment to lines 253 and 254, isn't that the law now? Why do you need that? I'm curious about that.
Well, I think all we're doing on 253, 254 is correcting what I would view to be some language that may have been left over from a previous version of the code. I believe that sentence is supposed to refer to the previous one, and which in the previous sentence doesn't talk about guardians or conservators. So I believe it's supposed to say that the personal representative or temporary administrator, if they're appointed without a bond, they don't have authority to receive the assets until the bond is posted.
I get that part. I get that part. What I don't get is do you need this law for the personal representative? I thought that was the law already. So are we changing the law in any way?
Not on that code section, Madam Chairman. I don't believe we are, other than we did add the sentence to make it clear that the bond has to be appointed. I think that was just to make that section consistent with the remainder of this act and to make, and to confirm what I think has been everyone's understanding about you needing the bond to receive the assets.
Well, and I'm a co-sponsor of this bill, and I support it. I've served as county administrator, and the difference between $15,000 and $25,000 is not worth 10 years of fees and oversight. But you and I have talked about this, and I'm interested if you've had any greater thoughts, or anybody else on the committee does. I don't think at line 60, expenses of litigation are really defined anywhere in the code, and I wonder if anybody has a nervousness about that term that would reduce $50,000 or down to less than 25,000 pretty quickly. 40% attorney fee. Let me double check.
Yes.
Yes,
Expenses
yes,
of
sir.
litigation on line 60.
Does anybody have any thoughts about that? Am I wrong? Am I wrong to worry about that? Probably I'm wrong to worry about that, is how I should ask it.
Well, Madam Chairman, I think you're always wise, the things you raise and the issues you come up with. It was not one, admittedly, that I had discussed with some of the interested parties, and they did not suggest any further definition of that language there.
Thank you,
I
Mr.
guess
Chair.
I'm thinking the thought is judges will using their discretion try to control some of those numbers.
Well, that's where I got confused, because if it's less than 25,000, who reviews it?
Well, that's true. That's true. If it's not being vetted through a court, that's
Yeah.
correct.
It's I've always been confused about what has to be approved by what court, but
It's your number, Mike. Representative Wilensky.
Thank you, Chair. Are you referring to line 67,
60.
60?
Expenses of litigation.
So the way this works, and why this is so important, but the way this works is when you're representing a minor, obviously, if there's a settlement for $15,000, it then has to go through the court.
Probate court,
Correct.
but not through any other court. If the parent settles with the insurance company for $25,000 or $24,950 now, nobody reviews that. And if the award was $50,000, but the expenses of litigation were taken off, and that's where I'm
Yeah.
confused.
So in these cases, the money is going to the parents because they have the claim for the medical bills and the child has claim for the pain and suffering. So when we settle for $15,000 currently, it would have to go to the court. Now this could take 6 months just to settle for this small amount. So by lifting to 25,000, an example I give a lot in trial, but it's a perfect example. In 2000, the highest quarterback paid in the NFL was $9 million. Now it's up to 35, 45 million. I mean, it's just the amount of value is going up. So where this used to protect these, where this was seen as a threshold of these cases are valuable enough where we need to protect them. And we're increasing the number because 25,000 is not nearly as much as it was when this law was written. But the money is mostly the reason we're not reviewing it and why we're raising this amount is because that threshold of 25,000 is what 15,000 was a while ago. And it doesn't need to be reviewed by a court because it's such a small threshold that the money is going to the parents and the child. Is that
I get all that.
okay?
What I don't get is who decides what the expenses of litigation are that take it from a $50,000 check down to a $24,950 check.
That would be the contract between the attorney and the client.
As well as the attorney's ethical obligations to adequately report what the expensive
so-
litigations are, the filing fee or
Well,
the different.
so this would
expenses.
be-
It is the ethics of the lawyer.
Yeah, so
Absolutely.
it is the ethics of the lawyer. And this, when you're settling for this amount, usually it's prior to litigation. It's pre-litigation.
Yeah.
So the expenses would be very small. In an injury case, the only expenses you would have is for mailing, is for getting the bills and records. I mean, there's some attorneys that gets charged for faxes, but there's not much expenses for pre-suit in these
There's
cases.
not much of legitimate expenses.
That is fair.
Thank you. I've raised this several times, and I think I support the bill. I think $25,000 is a correct amount. And the nervousness I have about this issue, it is up to the ethics of the lawyer. And I'm okay with that. Just wanted to raise it if anybody else
I
thought.
think it's
that.
an important discussion we're having. So maybe some hands. Any other questions in the room for the sponsor? We have a few witnesses. All right, seeing none. First witness that we have is Chief Judge Gregory V. Sapp, State Court of Chatham County. Hi, Judge Sapp. Thank you for being with us here today.
Thank you, Mr. Chairman. State Court Judges Council began working on this last year. Representative Burchett helped us drop HB 1108, which dealt with the anomalies in 2933 that are being addressed in this bill. The current version incorporates those changes we'd like to see made that will help litigants and judges, frankly, trial court judges in the state of Georgia, as well as the attorneys involved in these complicated cases sometimes. So we applaud the changes that are made. We support the substitute bill, and we realize that the sponsors have worked with the Probate Court Judges Council as well in addressing some of their issues. So at this point, unless someone has any questions about the mechanics of how it works from the trial court level, State Court Judges Council would suggest approving the bill and letting it go forward. Thank you.
Thank you, Judge. Any questions from the committee for Judge Sapp? Yes, I'll recognize Chairman Scoggins.
There's a bill still going in the Senate. Is that correct, from the state court judges? Is that correct?
No, there was going to be, in fact, I see Mr. Tolbert there on the screen. He had helped us revise a draft that Senator Strickland was going to carry when it became aware that this effort was going forward on the House side. It was determined that maybe the best option would be to go ahead and try to fine tune this House bill, save you guys the effort. The Senate is busy and the Judiciary Committee is busy like you guys are over here. I just learned about 2 hours worth of election law waiting for this session to start. And I appreciate that, but the effort was consolidated here. We're happy with what was done here, and we're prepared to go forward and support this in the Senate.
We're always happy to help
Thanks,
our
sir.
friends in the Senate with perfecting legislation. It's a full-time job down here. Any other questions for Judge Sapp? Judge, thank you so much for being with us here today. Appreciate
Thank
it.
you very much.
All right, we also have Mr. Adam Malone, who's here with us in person. If Mr. Malone is in the hall, he can come on in. Yeah, if you don't mind. Thanks. Mr. Malone, thank you for being here with us today. And if you don't mind having a seat, committee would like to hear any testimony you want to give.
Mr. Chairman, thank you for having me. Shall I remain masked?
You're welcome to remove it if you'd like to while you're
Thank you.
speaking.
So thank you, Mr. Chairman, distinguished members of the committee. I'm Adam Malone. I'm here on behalf of the Georgia Trial Lawyers Association. And here to speak in support of the substitute House Bill 620, minor settlement bill. I want to take a moment, though, and acknowledge and express great appreciation for the hard work that the fiduciary law section of the State Bar put into this bill, the probate judges, the state court judges, and the Judicial Council. There's been a great deal of work that's been done on this bill over the last several months. I know it was here last year, but since the summertime leading up to the present time. And I just want to say, I think that it solves a problem, brings clarity to a lot of confusion about when and in which court minor settlements need to be approved and when they need to be reviewed and approved. It streamlines the process and it saves a lot of money, while at the same time providing judicial oversight for those that we care about the most, and that is our minor children. So I'm happy to answer any questions you may have, but fully support this bill.
Thank you, Mr. Malone. Any questions for the witness? Seeing none, thanks for being here today. Really appreciate your time, and I appreciate all of our witnesses for waiting as we had a delayed start to the committee today. I know it's been several hours, so thank you.
Well, we all appreciate the hard work that you're all doing, and thank you for having me.
Thank you, sir. All right. Any other discussion from the committee on House Bill 620? All right, seeing none, I'll entertain a motion at this time. Is there a second? There's a motion and a second on committee substitute to House Bill 620 LC 413052S. All right, I'll now hear an amendment from Representative Leverett.
I would move that we amend line 253 of LC 413052S by striking.
Sorry, I didn't hit your mic.
Oh, I'm sorry. Thank you, Mr. Chairman. I would move that we amend LC 413052S on line 253 by striking at the end of that line the words "a guardian or conservator" and replacing those words with "such personal representative or temporary administrator."
Is there a second? All right, any objection to the Leverett amendment? All right, hearing none, it's adopted. Any other amendments from members of the committee? All right, hearing none. Any other discussion? All right, we'll call the question. All those in favor signify by saying aye.
Aye.
Any opposed? All right, that's our second bill. So for scheduling purposes, at this point, we're planning to have a full Judiciary Committee meeting on Wednesday at 3:30 in room 406 CLOB. Wednesday, 3:30, 406 CLOB, and there will be a Zoom option. Thank you all for being here. We're adjourned.